begin. Be seated. Now is the time set for oral argument in cause number 1 CV17 0765, National Tax Lien Redemption Services, LLC et al. Versus James M. Rivers et al. For everybody's information, as we did in the first hearing, we are both audio and recording these proceedings, so barring any problems with that system, it'll be on YouTube in a couple of weeks. Counsel, as before, each side will be entitled to 20 minutes. We would ask that you respect the time period. The timer on the podium will let you know how much time you have left. And for the appellant's purposes, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know. Ultimately, however, it will be up to you to reserve rebuttal time. We've reviewed the briefs and conferenced the case, so we've done that this morning, so we are well aware of the facts and issues attendant to the argument. You might want to keep that in mind again for purposes of how you choose to couch your argument. Counsel, when you each come to the podium, I would ask that you state your name and who you represent. And once again, counsel, you may begin.
Richard Treon, for the record, on behalf of Rivers Treon, here today with my co-counsel, Jerry Cochran. We will divide the time between us, and if there's any time left over for rebuttal, we will reserve it depending on what's available. I am going to address the subject of whether the trial court erred in failing to grant summary judgment in favor of Rivers Treon on the basis that the premier and the lenders, the intervenors here, had actual and constructive knowledge and imputed to them all the facts necessary for them to know everything that Judge Talamonte said that Treon failed to put in the 1988 amendment to the deed of trust, which is the basis, in essence, for his judgment that the deed of trust would not be deemed to be valid and enforceable because there had been no amended deed of trust entered in 1988 reflecting the modifications that were made at that time.
I hate to put too fine a point on it right up front, but I need to just sort of align the parties here. Rivers Treon, if I understand it, is seeking to reinstate the right to redeem the tax lien on this property, correct?
We're asking the court to recognize that Rivers Treon had a valid and enforceable deed of trust at the time that judgment was entered against Diane Sweeney, and as a result of that, we have that right.
Is the answer to my question yes or no?
I guess it's yes.
So what that means is that this property is worth about $1 million now.
Possibly.
Okay. And so for about $22,000, you personally would be able to acquire $1 million property that sort of came into your sphere in connection with your representation of a client?
That's not true, Your Honor.
Okay. Tell me why I'm wrong. Why?
In 1988, I paid off the $120,000 deed of trust, that paid the deed of trust to Rivers that Sweeney owed, and had it.
He owes you $125,000.
He did back at that point in time, yes.
Been paid back?
Never has paid anything,
Okay,
and
so
the
he
property
still owes it.
The property is
Continues, counsel, correct?
yeah, the property is the source of the recovery.
We have limited time, so let me try and get. If you can answer a question in the affirmative or the negative, I'll follow up if I need to. But
right.
But if I understand it correctly, the Sweeneys, because they were a marital community, owe you $125,000. Because you paid as their guarantor $125,000 at some point.
Not to be technical, it's $120,000. The answer is yes.
Okay, so that debt still exists.
Theoretically.
And the basis of the claim here today is that you have stepped into the shoes of Rivers in a deed of trust, correct?
Your Honor, based on Judge Talamonte's finding, I had a beneficiary interest in the deed of trust because I was a part of the deed of trust proceeding back in 1986-88, and when I paid it off, I got an assignment from Rivers, and therefore I have a derivative of an assignment.
So is that a yes?
Yes.
Okay. Now, I just want to be clear. In connection with the underlying transaction, you represented Rivers and the Sweeneys.
In 1986, I represented Tom and Diane Sweeney on one hand and Jim Rivers on the other side. They each had separate representation. I was actually
You
facilitating.
represented them both on two sides of the transaction, and then yourself became a party to that transaction. Is that it?
That's correct.
Okay. And so now, if you win this case, you personally would stand to acquire quite a windfall, because for an additional $20-something thousand at this point, give or take some accrued interest perhaps, you would have the right to redeem $1 million property.
I'm sorry, I'm not understanding the $20,000 reference.
Well, I think that's the amount of the outstanding taxes.
At the time of the event, it was $27,000.
Okay.
And I tendered $44,000 in 2014 after Rivers was served, and tried to exercise the right of redemption, and the court would not recognize it.
I'm just trying to, I apologize for the math error. I'm just trying to align the parties and make sure that I don't make some grievous error in trying to understand how we get from A to B. Because it strikes me as potentially problematic to be a party to a transaction and represent as an attorney both sides to a transaction. You can see that, right?
And as a result of what happened in 86 and 88, I did what I was required to do ethically at that point in time, but that was never an issue in this case.
What were you required to do ethically, counsel?
Basically advise each of them to have separate counsel and have them advise them whether or not it was okay what I was doing by trying to facilitate helping Rivers on the one hand and Sweeney on the other hand, both of whom wanted to do the transaction. I was a middle person with no interest. However, because I was dealing with two clients, I had to guarantee the payment, because if it didn't get paid, one of my clients was going to lose, and I couldn't let that happen ethically.
So
That's
you
why
got
I paid.
waivers from each of the two parties, written waivers?
I believe they were.
And those parties clearly had competing interests.
Not at all. I mean, Rivers wanted to loan money and get 12% interest, and Sweeney wanted to borrow money and pay 12% interest and give a first deed of trust on a property that had equity.
Borrowers and lenders under the ethical rules are typically considered adverse parties. You may both want to get into the transaction.
Right. I see what you're saying. Yes, and I respect
And
that.
at some point, Sweeney didn't pay, right? Were
Correct.
they adverse at that point?
At that point, I paid.
Rivers and Sweeney, I thought you had just said, let's clarify this, that there was a unity, not a unity of interest, but no conflict. At the point in which Sweeney missed a payment,
Correct.
was there adversity?
I assumed there was adversity, and that's why I began making the payments. I made the payments that Sweeney didn't make, and then when he didn't pay the 120, I paid the 120.
But you did it
pursuant to
as-
my guarantee.
You did. I was going to say you did it specifically as a result of your position within the dealings as the guarantor.
In a written guarantee, yes, so saying that I would guarantee that if Sweeney didn't pay, that Rivers would get paid, and he was.
And why would you do that?
Because they're both friends and clients, and I'm not going to have anybody lose money in a situation where I'm facilitating and helping one party versus another party.
But you stood to lose.
I did.
$120,000.
I did indeed, and I did. And I lost $120,000 30 years ago.
Was there a demand for you to pay that $120,000?
From Rivers? I don't even know if there was a demand or not. To me, it didn't need a demand.
As soon as there was a missed payment, you just leapt in and paid
Yes.
one
That's what
client for the benefit of another client.
That's what I did. Now, if there's something unethical about that, I don't know what it is, and nobody's raised it with me. But
The actual ethical implications are perhaps beyond the scope of this proceeding. But the reason I ask is, again, this is a very unconventional case. Right? We're talking about agreements that are oral, that are 30 years old, that give you an interest in a recorded instrument that change the nature of that recorded instrument, but those changes are unrecorded. And all of this happens while you're participating in a transaction in which you represent both sides. And ultimately today, if successful, you would benefit more than either client. So I have to ask if public policy concerns are implicated. I'm not resolving any ER issue, but there seem to be some public policy concerns there.
I'm not gaining anything adverse to any client. Rivers was paid $120,000 in 1988 plus all the interest that was due to him. Sweeney had no money coming to him. Sweeney owed the money.
And Sweeney still owes you the money.
That's exactly right.
Have you made demand for that?
Many times. You can't get blood out of a turnip.
You represented Ms. Sweeney not half an hour ago in this courtroom.
And it is indeed, because she needs a lawyer.
But,
Jim Crook was going to be her lawyer, but unfortunately he's sick today.
Okay, but Ms. Sweeney still owes you $120,000.
I don't believe she owes me a penny. The property owes me the money.
How is that?
Because Tom Sweeney is the one that borrowed the money. He's the one that had the business. He's the one that
They
lost it.
were married at the time, right?
Yes, they were.
So there's a community debt.
Technically, she owes me the money, but I would never, ever enforce that debt. To me, it's not a debt. It's Tom's obligation. Tom cheated her. Tom cheated me. And I'm the fall guy here that I guess acted unethically by helping people.
Did you also, while you're talking about what Ms. Sweeney may owe you legally, but you're willing to deal with in whatever regard, she is a debtor to you at the same time you're aligned with Mr. Rivers in this case, correct?
Well, yes, and myself, we're in the same position.
I'm sorry?
Rivers and myself, in regard to the deed of trust, we're in the same position. But we're not adverse to Diane Sweeney. If she gets title, then the deed of trust that was existed on the property that existed on October 9, 2012 still is extant and still is enforceable.
Let's
Nothing
talk
changes.
technically about the deed of trust, just to make sure I understand. The original deed of trust had Rivers as the beneficiary,
Right,
right? Sweeney's as the trustor.
correct.
Who was the trustee?
Western something, I can't recall, Western Bank or somebody, they're out of business.
Okay.
In addition, the promissory note was listed on the deed of trust. You acted on your documents. There were documents. There was a recorded deed of trust that said $120,000 was loaned by Rivers to Sweeney, and that the property was properly recorded according to its legal recording requirement. And there was a written guarantee between me and Rivers.
Well,
Those
if
are written
there's
documents.
one thing we can be certain of in Arizona over the last 10 years, it's that you don't have to show the note. But I want to talk about the deed.
Okay.
Under the deed, you as guarantor satisfied Sweeney's obligation to Rivers. Is that correct?
Right.
Okay. So Rivers now has no more claim to monies owed and no more enforceable security interest in the property because there's no way essentially for Sweeney's to default against Rivers.
Correct. Rivers is the nominal party who stayed on the paper because he was the holder of the deed of trust at that point in time. And the idea there'd be litigation rising out of this and Sweeney wasn't going to pay it or he wasn't going to pay the taxes was 30 years away.
You're focusing on facts. I want to move to law for a second.
But let me just suggest, if I may, you're in an area where Jerry is the person who's going to handle it. He has the answers, I think, as a real estate specialist to your questions better than I can give.
If you'd like me to defer those questions to him, I'd be
Well,
happy.
we're down to 7.5 minutes, so.
May it please the court, Jerry Cochran representing Mr. Treon in this matter, and excuse me, my hand cramped
Do you
up.
represent Mr. Rivers as well?
I do.
Okay.
And Rivers.
What's Rivers' interest in this?
Well, Rivers' interest, according to the documents and the rules, and Rivers has Mike. I'm having a senior moment. Has conservator counsel who represented him in the trial court level.
But he hasn't. I can't imagine what his standing is to participate
No,
in this.
I believe that he has very limited standing. There was a residual agreement with Mr. Treon that if he got the property and he worked forward with the Sweeneys on a joint venture agreement, he would share in the profits with Mr. Treon. As of
Why
right,
would he need to work forward on a joint venture agreement? What would be the interest that would prompt him to do that?
Pardon?
What would be the interest that would prompt him to need to work with Mr. Treon on a property development agreement?
Well, I believe what Mr. Treon had done since he took over as guarantor, that if he got more than just his money back, the principal and the interest.
We switched lawyers here because I had a question pending,
Yeah,
and
no,
it still hasn't been
yeah.
answered. When Rivers' interest in the property was extinguished by having the debt satisfied, how, as a matter of law, did that deed of trust transfer beneficiary to Mr. Treon?
Two means. In the evidence in the declarations at the time.
I'm not interested right now in the evidence and declarations. I'm asking you as a matter of law. Do you
As a
have
matter,
statute?
as a matter of law, in the case law we've cited on guarantor on subrogation, when the guarantor pays the debt, he subrogates and he gets assigned to all rights of the debtor, including rights in the collateral. So as a matter of law,
All
it was
rights
there.
of the debtor. But here,
I mean, all rights of the creditor in the collateral. Case law cited in the briefs, at the trial court level and at this level. When you've got a guarantee situation, it's basic guarantee law. You satisfied the guarantee obligation. You're subrogated to the rights of the creditor, to the debt and the collateral.
so presumably then, under this theory, because I think your position also is that doesn't have to be recorded.
It does not. I mean, if you read Manicom and the other cases.
Presumably then, if ABC Company comes in and buys out Mr. Treon's interest in the Sweeney obligation, and then that sells to CDE Company, and then Betty Larson buys it from CDE Company, and all of these are oral and non-recorded, then one could prevent this lien from ever having a redemption foreclosure, because potentially everybody in the state could have some interest in this security.
No. I believe the situation is absolutely critical. If you look at one of the trilogy of the leveraged land cases, and I forget which one is, the risk by not recording the assignment is if Mr. Rivers got served, did not defend, and did not refer it to Mr. Treon, and there was a default taken, that binds all the predecessors, all the successors that didn't record their interest. In this instance, Rivers was served. He got a hold of Mr. Treon, who was the assignee, who appeared and defended, had the right to redeem.
But
But
under
that's-
my sort of absurd hypothetical where you have many successors, one could imagine people just texting one another and saying, hey, I've just been served, and involving dozens of successors in interest with unrecorded interests who get actual notice and appear, right? And so we could actually be litigating dozens of these oral agreements.
Well, you just get one, you track this thing, who's got the final assignment rights.
If people agree on the facts.
If people agree on the facts. If not, that's what the case. But when you appear and it's before the court that you're asserting the rights through this assignment, that's what, if you read the cases on the deeds of trust, they put the duty on anybody that's trying to get rid of a deed of trust to contact the beneficiary or the trustee, or both, and serve them. Dalo, Manicom, the leveraged land cases, they have an interest in the property that could be protected. And to answer your question, Mr. Tran doesn't get title to the property. It may be worth $1.6 million, $1.7 million. He has a deed of trust that was recorded that the debt is outstanding.
But if successful in this case, Mr. Treon gets the right to redeem for some five-figure amount.
Correct.
And Mr. Rivers really gets nothing, right? Because
Correct.
He's been paid off. And so for some five-figure amount, now we've got a $1.6 million asset in play out of this transaction. I just
And you've
wanna
got a
make sure that we
$500,000
don't state the facts wrong.
And you've got a $500,000 debt against it, which was recorded. This case sets every principle of my 35 years of practicing real estate on edge. Because,
admit,
well,
it's
let me tell
novel
you,
to me
because,
too, yeah.
because If people had done their jobs, the first instance, you get this trial court where these tax practitioners file 8 properties together, so even the plaintiffs couldn't keep track.
Well, counsel,
who was
let
on-
me stop you. You're a real estate lawyer?
Yes.
Transactional? How often do you represent both the borrower and the lender?
I do not.
Have you ever?
No, I've referred matters out. You know, you get to
Represent the buyer and the seller?
No, don't represent the buyer and seller.
If you
But-
represent the buyer, do you, or the seller, or the borrower, or the lender, do you also guarantee the obligation?
No.
Okay.
But that doesn't vitiate the fact that if that has occurred and it's a transaction that the borrowers agree to, it may have ethical obligations, but it doesn't affect the transaction legally. Doesn't affect all the affidavits, doesn't affect all the things. There may be ethical implications, but it's not legally that it makes the transaction.
Well, and
Is there-
if there are ethical implications, do they raise public policy implications that can go to the enforceability of an agreement?
I believe it's possible they could, as if the 2 parties were objecting to it. But now you've got third parties coming in here, and then they'll get back to why this thing is egregious on this whole thing, this cluster stuff. Everything. You've got a recorded deed of trust. As you go forward and you say as to what happened with this property, it gets foreclosed. The judge grants a treasurer's deed when there's still on the surface of the case a lien outstanding that hasn't been served, and grants 54B language so you get a treasurer's deed done. There's a lis pendens and a recorded deed of trust. The title companies choose to ignore that, including when the construction loan gets put in place. The buyer now knows that the lien is in place. The title company and the escrow agent knows the lien's in place. They don't tell the lender. So all this stuff on an equitable thing, if all of that hadn't happened, the testimony of the lender and the buyer is, had they known of the deed of trust, normal practice is, it appears on a title report. The escrow officer or one of the parties contacts the contact on the lender and find out what's the lien. That's all of your notice cases out there on constructive notice. And they either get it paid off or don't go forward, or they litigate this issue then.
Counsel,
Yeah.
we're out of time.
Oh, I'm sorry, Your Honor.
All right. Thank
Any
you.
further questions, and if I'm done. Thank you.
Counsel, curious. Do we actually have a deed of trust in play at this point that has been recorded? Or are we talking about an oral assertion as to the modifications of what used to be the written provisions of a deed of trust?
And before I answer that, Judge, just to clarify for the record, Scott Malm of Gus Rosenfeld on behalf of the lenders, the same parties in the last argument, and I also will reserve some time for the owner's counsel, Rick Cobb. To answer your question, there is a recorded document called a deed of trust that secures an obligation known as a promissory note of 1986. But because there is not a valid debt of that 1986 promissory note, there is not a valid deed of trust.
So why is your colleague wrong about the doctrine of subrogation?
I don't know. I don't think he is wrong on the doctrine of subrogation. Yes,
So-
they subrogate into all of the rights that Mr. Rivers had. What rights did Mr. Rivers had to pursue the obligation known as the 1986 promissory note?
Well,
As
isn't-
you heard before,
When one pays a guarantee on a note, isn't that the liability then that one has a right to enforce?
it's not the liability on the guarantee, it's they step into the shoes of the underlying debt. The underlying debt is the 1986 promissory note,
So what?
which is unenforceable.
It's unenforceable. Why? Because it's been satisfied?
Several reasons. One, a lost note. I heard the documents show there is no 1986 note anybody can show you. So to
I
satisfy.
can't believe we're having this discussion. After the Great Recession, when we litigated show me the note cases time and time again, you can't be arguing that one must be able to show the note.
I'm not saying show the note. I'm saying show me a copy of the note. Show me anything about the note. That there is a very big distinction between those theories. The show me the note cases, because I was involved in a number of those.
Oh,
yeah, I know. Yes, and so what was involved there was when the lender would come in with a copy of the note, the borrower would say, hey, that's not the original note. You need to show me the note. That's what those cases we're talking about. Here, it's something completely different. There is no written record evidence whatsoever of a 1986 promissory note, so they have to satisfy ARS 473309, which they don't.
That's the UCC.
It is a UCC provision that deals with it.
That's not really what governs deeds of trust.
Yeah.
We're talking about two different things. The deed of trust goes away if there is no underlying obligation. So we look at 473309 on whether or not you have an obligation, the promissory note itself. So that's one reason for unenforceability. There are several others, but I don't want to give up on the argument about lost note, because this is why you have a statute that says if you're trying to enforce a lost promissory note, you need to offer certain things, because otherwise everybody would come in and say, I have a promissory note, you owe me money.
Your argument is nobody's trying to enforce that note. Mr. Treon just got up here and said he hasn't tried to enforce it at all. He's never tried to foreclose on the deed of trust. He's only asserting standing to redeem the tax lien. So there's no adversity with regard to the note.
Agreed. And so that would go to our argument about novation. So the problem we've had here is various arguments keep popping up and we're trying to address them. So when we said there is no promissory note, written evidence of it, lost note, well, we're not really pursuing the 1986 note. We're pursuing this joint venture agreement is what I heard before.
Is it even that complicated, though? I mean, aren't they just pursuing some sort of standing to be welcome to the redemption party? They're not pursuing any agreement. Nobody's trying to do a joint venture. Nobody's trying to enforce the terms of an agreement, a deed of trust, or a note. This is all about standing, isn't it?
To have standing, to redeem the taxes, you have to have an interest in the property. A deed of trust is an interest in the property. If this deed of trust is valid, they do have the right to have redeemed and they have standing. That's why we're focusing on, but do they have a debt that they can enforce? Because if they don't have a debt, then regardless of whether this is recorded or not, it's invalid. If
what
you don't,
specifically is invalid?
the deed of trust interest.
Because it has gone away when the obligation that the deed of trust secures goes away.
Correct.
So
Whether
it's acknowledged that subrogation is in play here.
So the deed of trust is in Rivers' hands. When Mr. Treon pays it off, Mr. Treon then steps into the shoes of Mr. Rivers for the deed of trust. He can enforce the deed. He can redeem the taxes if he has a deed of trust interest. That's why we're focusing on, is there a deed of trust interest that can be enforced? Under Best Fertilizer case, under Weatherford v. Adams, if there is no obligation, then regardless of whether you have a recorded deed of trust or not, it can't be enforced. If he can't enforce the deed of trust, he can't redeem the taxes. So you're right, the issue is standing. Does Mr. Treon and Rivers have an interest in the deed of trust, giving an interest in the property to redeem the taxes? And we're saying no, because they don't have an obligation to enforce, either under the lost note, which I'll set aside, or because there's a substitute agreement and there's novation.
Well, would you dispute that Mr. Treon, as guarantor, satisfied the obligations to Rivers?
For purposes of the motion for summary judgment in granting it in our favor, we can concede that point.
Okay. So when a guarantor pays off, there are legal consequences to that don't require an agreement, right?
Mm-hmm.
Why doesn't that end the inquiry?
Because it allows Mr. Treon, under the subrogation cases, to step into the shoes of Mr. Rivers to enforce the deed of trust. Mr. Rivers couldn't enforce the deed of trust because the obligation, the 1986 promissory note, can't be enforced.
Oh, but
Which note?
The 1986 promissory note.
If when a mortgage gets sold, and I know that's a colloquialism, but you know what I mean. When a mortgage gets sold, the original lender is satisfied, right? The trustee may remain the same. The beneficiary may change. Why isn't this exactly the same thing? Just because the original lender can't enforce something for which he's been satisfied, that doesn't mean there isn't a debt to which the security attaches.
You're making an argument we're not making. I'm not
even making an argument. I'm trying to make an analogy.
Yeah.
And ask you where the holes in it are.
And we're conceding under all of the subrogation. I had a handful of those equitable subrogation cases, which are exactly those scenarios. When another lender comes in and satisfies the prior one, they step into the shoes of. But the point is, there has to be something that you can enforce when you step into somebody else's shoes.
And?
Does Mr. Rivers, under this deed of trust, have an enforceable obligation that he can enforce against the Sweeneys?
Well, he did the moment before he was paid off.
Yes. Yes, back in 1988-ish, something. We have, again, for purposes of the summary judgment, we have no reason to not believe that. Correct. And so at that point, the question becomes, is that promissory note enforceable? And we say it's not, because when Mr. Treon paid off Mr. Rivers, according to Mr. Treon's own testimony in his deposition, we cited this is from page 177 of his deposition, then we would implement the substitute agreement. You see, as you heard before, that's where this joint venture idea comes in. Mr. Treon pays off Mr. Rivers for the benefit of his friends, the Sweeneys, enters into a new agreement with them, a substitute agreement.
Is this the oral agreement that occurred?
Yes. This is the separate agreement that the Gila County Superior Court held, and those were the phrases. So we have the phrase substitute agreement, separate agreement, joint venture agreement, all of these new terms dealing with the time period. So that's the idea of novation under the Maxwell case from 1995. It said, if there's a substitute agreement, because you can't have two agreements for the same $120,000 that's owed. You have one, or you have the new one. And if you have the new one, that terminates and extinguishes the old one. Well, the problem is, under this deed of trust, it doesn't say it secures the 1986 promissory note and any modifications, renewals, replacements, any of those kinds of things. They live or die on their argument based on whether the 86 promissory note is enforceable.
Counsel, let me ask a real quick question. Did the trial court buy that argument? What did the trial court's holding hinge on? Was it that argument, or was it another argument? Maybe there was evidence of, or no evidence of a subsequent agreement or statute of frauds, or was it that?
Well, first of all, there were no specific findings of fact, conclusions of law, other than a couple of paragraphs on the minute entry. But the judge also then said, basically, for all of the other reasons that we argued. So, yes, to that extent, he incorporated our argument, which was novation. The judge specifically didn't say in his minute entry novation. What he focused on was the issue of, it was an oral agreement, and this doesn't say it secures an oral agreement reached in 1988. It says it secures a 1986 promissory note. So,
and given then the impact of your reading of the testimony concerning the 1988 agreement, and the course of performance suggesting no effort to enforce the subrogated guarantee liability, why isn't that a dispute of fact? A triable issue?
Because it's Mr. Treon's own words saying it's a substitute agreement. So him saying it's a substitute agreement is the same words as what, as a matter of law, or the definition of a novation. And when the Superior Court in Gila County says, I'm going to create this conservatorship based on the fact of what you've told me about this separate agreement, There's no disputed issue of fact about those two
I
things.
think Mr. Treon, not to put words in his mouth, but I think would differ with you on your interpretation of the substitute agreement. Right? I mean, that's why we're here, is he's going to say, yes, we had a substitute agreement, but that was all premised on the fact that I had this security that I had become subrogated to.
A party shouldn't be able to create a disputed issue of fact by saying multiple different types of things. We're holding him to his words of, it was a substitute agreement. We're holding him to his words, it was a joint venture. We're holding him to even accepting the truth of the matter of what he's saying for summary judgment purposes, that there were new terms added, such as sharing profits and equity.
Counsel, was it just a party, or Sweeney is on board with that narrative, right?
Yes, yes. So
all the interested persons, excuse me if I may, so all of the interested persons in that deed of trust and that earlier note, agreement, whatever you want to call it, they all agree that that took place. They all agreed that the provisions of the deed of trust were changed.
I think you meant to say all of the provisions in the promissory note were changed, because they never said anything about the deed of trust itself.
Well, I'm asking you, as a matter of law,
Right.
if you change the provisions that drive the deed of trust, is it still the same deed of trust? We happen to have a deed of trust out there, and it's a completely different issue, completely different values, completely different recourse. But we're gonna say that deed of trust controls this new note, this new circumstance. Can you do that?
No. And under the language of the recorded deed of trust itself, it says you can't have oral modifications. It has to be in writing. So if you have a recorded deed of trust that says this secures the 1986 deed of trust, or 1986 promissory note, that's what prevents somebody from coming along and saying 30 years later, oh, by the way, everybody, didn't tell anyone, didn't record anything.
At a meeting.
We have a meeting and a few text messages, and we came up with a new deal, and oh, this obligation is also secured by that. That's not how it works.
Anything in the evidence concerning the 1988 agreement that suggests that security was to be abandoned, or that the $120,000 that had been paid as part of the guarantee was forgiven?
There is nothing in those declarations that even addresses whether the deed of trust is in play or not relating to their 88 oral communications.
So if you want summary judgment, you need to demonstrate not only that there are facts that may be undisputed in your favor, but that a reasonable jury must also, not could also, but must also find in your favor, right?
Correct.
With all of these unanswered questions and unanswered facts, was summary judgment appropriate?
Yes, because there weren't unanswered questions.
I've asked a bunch that haven't been answered.
Well, question number one, what obligation is secured by the deed of trust? The 1986 promissory note. Question number two, what was there the 1986 promissory note entered into evidence? No, it's a lost instrument then. Those aren't undisputed facts. Then if you go to our second argument about novation, was the new 1988 oral agreement a substitute agreement? And we're using Mr. Treon's own words to say, yes, it was a substitute agreement. We're using the Gila County Superior Court's specific finding that it is a separate agreement. So that's why there is no disputed issue of fact. This doesn't match the agreement.
Pardon me. One could use the term substitute agreement to mean a lot of things, and it doesn't have to mean novation, right? The term substitute agreement could easily refer to a loan workout, right? I'm behind on my payments. The lender agrees to extend them. That's a substitute agreement. Still secured transaction. Why are these words substitute agreement so magical in your ears?
Because this deed of trust is not the kind of deed of trust that I believe you're thinking about from past experience, which would say this deed of trust secures the 1986 promissory note, and any modifications, renewals, amendments, or anything else, or even other debts. Then we would have a duty to go explore, did any of that take place? This is specific, and it's not disputed. The obligation is very specific. 1986 promissory note, there is no 1986 promissory note being enforced.
So when we start talking about for for some reason in my mind, I'm seeing three categories of changes having to do with Miss Sweeney's mother, that it wouldn't be collected upon if she remained in the premises, if they weren't making the payments and all that. You're familiar with what I'm talking about?
Yes.
Where did that agreement, where did the agreement that was alleged to have been reached in 1988 put the 1986 deed of trust? Because you've changed all the provisions that allow for collectability, redemption. Do you have a 1986 deed of trust that's viable?
No, that is our argument. You do not have a 1986 deed of trust because you don't have a 1986 promissory note. You have a 1988 oral agreement, and between Mr. Treon and his friends, the Sweeneys, they can go and work out their enforcement, but they can't claim an interest in the property because the deed of trust is so specific. Judge, I do want to reserve some time. I'm happy to answer any question, but I do want to reserve some time for Mr. Cobb, but I'll keep answering your question.
Can they move against the deed of trust based upon the agreement that's currently in place?
Correct. They go again. They're trying to claim an interest under the 86 deed of trust under a 1988 oral agreement that is different.
They are inconsistent.
They are inconsistent. They are different.
Good morning again, Your Honors. And if it may please the Court, I'd like to just add to what my co-counsel has said previously, and that is Mr. Treon admitted, and it was undisputed, that he put a different term into this. It wasn't just that they changed the payment date, because it happens all the time that you change the payment date on a note, and you don't have to go get a new deed of trust. But if you say, we're not going to be lender and borrower, we're going to be joint venturers, and I'm going to split the proceeds that we make because this house, the land itself had gone up in value, then you become joint venturers with him and you're no longer a lender. And that was the testimony. It is on page 35 of Mr. Maum's brief that they agreed that they would split the proceeds that came out of the deal in the event that Mr. Treon were to take the property back at some point, because there would be a huge windfall sitting here. And that is such a material term to where he's not a lender anymore. He used the term substitute agreement, a joint venture, because that's what they agreed to do. They agreed to either develop the property and split the proceeds or to sell the lot at some point in time. And that is why this is a novation. It's an entirely different agreement. They're not borrower and lender anymore. They're partners now. That extinguished the note on the spot because it is no longer a lender-borrower relationship. And that was the reason why we made the novation argument. Now, if I may, in addition to that, the statute of limitations runs on this. The original note is a demand note. They all admit this, that it's a demand note. It doesn't have a date for repayment. It's a 1986 note. 6 years later, 1992, that note would have expired. They say in 1998 we came up with this plan whereby they could stay in the house until Claire Sweeney dies or moves out. And so that theoretically resets the time into like forever as long as she lives. And the problem with that is it's not in writing. And they all admit it's not in writing and it's not recorded. So if you look at the Manacom cases and those kind of cases that make you aware of things you can figure out by looking at the record, you can't figure that out. In Manacom, you had a legal description and you had a street address that were different. And if you went and looked at the legal description, it said slide 168. It should have been slide 166. And if you looked at the legal description, it wouldn't match slide 168. And so they said a title examiner looking at that could look at that and realize you had a problem. But in our case, if you go and you look at this and you see a 1986 deed of trust, and you're sitting there in 2012, right? You say to yourself, that is a stale deed of trust. And there's nothing about it that suggests that there's a problem with it, that there's a 1988 amendment. It's just not recorded. It's not in there. And that is the Hall versus Worldwide Lenders decision, which is why we gave you that. Because you have to be able to show something from the record that we can then look at when we go to buy the house that puts us on notice that we should inquire about that. Otherwise, we're entitled to look at that and say it's expired, as has my time.
There you go. Thank you, counsel.
Thank you, Your Honor.
It's been an interesting morning. We're going to take this under advisement at this time. We appreciate your time today, and we'll be getting back to you.